Hello and welcome. You're watching To The Point. Yesterday, Kanhaiya Kumar was released on bail and delivered a riveting speech that held audiences spellbound. Indeed, Arvind Kejriwal called it brilliant. But this morning, there are fresh concerns about Kanhaiya Kumar and his clash with the police. Did his speech wittingly or unwittingly breach the conditions for bail laid down by Justice Pratibha Rani? What impact will those conditions have on his immediate future? And are there grounds for appealing to the Supreme Court to overturn them? My guests are former Supreme Court Judge Justice A.K. Ganguly, the Additional Solicitor General Sanjay Jain, and Senior Advocate Anil Soni. Both Mr. Jain and Mr. Soni appeared for the state against Kanhaiya. I'm also joined by two well-known and highly regarded Supreme Court lawyers, Prashant Bhushan and Sanjay Hegde. Sanjay Jain, let's start with the speech Kanhaiya Kumar delivered last night. He said he would fight for Umar Khalid and Anirban Bhattacharya. Does that breach the following condition laid down by Justice Pratibha Rani when she granted Kanhaiya bail? And I'm going to quote her. She said, he will not participate actively or passively in any activity which may be termed as anti-national. Could fighting for Umar Khalid and Anirban Bhattacharya be termed as anti-national?
Not directly, unless it is established that Umar Khalid or Anirban are themselves indulging in anti-national activities. There is no inherent presumption to the effect that merely because he wants to fight for them, it will automatically be anti-national, that it would be a breach of the bail condition.
I'll tell you, Mr. Jain, why I asked that question, because in paragraph 21 of her judgment, Justice Pratibha Rani says Umar Khalid was the person who took permission for the 9th February 2016 program, which she then describes as being anti-national. Now, if the program he took permission for is anti-national, does that make him anti-national? And then, does it make fighting for him something that becomes anti-national?
No, fighting per se would not be anti-national. But if Kanhaiya Kumar comes to a conclusion, or if he decides that he would fight for them on the issues which the state is perceiving as anti-national, then in that condition, this would be a breach of the bail condition.
Prashant Bhushan, last night Kanhaiya Kumar was addressing JNU students as president of the Students' Union. There was at least one poster which, amongst other things, called for the release of Comrade Gilani. Does that poster breach another condition laid down by Justice Pratibha Rani? And once again, I'm going to quote her. As president of JNU Students' Union, he will make all efforts within his power to control anti-national activities in the campus. Does a poster calling for the release of Gilani, which arguably could demoralize the family of martyrs, another one of Justice Pratibha Rani's concerns, does that amount to anti-national activities?
Well, the very fact that you are asking this question seriously shows, in my view, the absurd nature of the order passed by her. Nationalism or anti-nationalism is not an offense under any law. It's not defined by any law. Firstly, for her to expound on her view of nationalism or anti-nationalism was totally uncalled for. Secondly, she goes on to say things like there is infection, antibiotics, gangrene, and so on and so forth. You see, it's more of a political speech than a judgment of a court. She had no business to go about saying that what was happening in JNU was anti-national, or that this amounts to some infection or gangrene, etc.
Okay.
These are the kind of political speeches that the BJP spokespersons, etc., go on making. This is not the business of a court to go into that. The court had to judge whether Kanhaiya has committed any offense, whether there is any reason not to release him on bail or not.
Okay.
The only offense that he was charged of was sedition. Sedition has been very carefully and clearly read down by the Supreme Court to mean something which amounts to an incitement to public disorder or to violence, etc. And Kanhaiya, she accepted had not made any statement which even she considers anti-national,
right.
etc.
Let me-
Therefore, for her to expound on all these things is a political speech rather than a judgment of a court.
Justice Ganguly, in a sense, the questions I've just put to Sanjay Jain and Prashant Bhushan all hinge on a third question, which is, what is anti-national? Justice Pratibha Rani, in her bail order, frequently uses the term as a condition that Kanhaiya must not breach. But am I right in asking that anti-national is a term that is not defined in law? Secondly, anti-national is a term on which there could be multiple interpretations and meanings, and there is no agreed definition. And therefore, given those two facts, was Justice Pratibha wrong to use this term in her bail order?
Well, to be very honest with you and with great respect, the learned judge has held, at least expressed her opinion, that we are enjoying our freedom of speech because soldiers are guarding the borders. I mean, this kind of interpretation of freedom of speech has never been found in any judgments of Supreme Court or High Court. This question often comes before Supreme Court, and he has quoted this Shreya Singh's case, where the learned judge has said that this right to freedom of speech has three parts. First is the question of discussion, then advocacy, third incitement. The learned judge of the Supreme Court made it clear that as long as it is the stage of advocacy, even at the stage of advocacy and discussion, 19(1)(a) rights are not breached. But when there is incitement to an offence pursuant to the discussion, it may be breached. In the case of Kanhaiya, there is no such incitement.
Can I interrupt, Justice Ganguly? Beyond the point you're making,
And another thing, one more.
Can I just ask you this, Justice Ganguly? Am I right in saying that anti-national is undefined in law, and therefore Justice Pratibha Rani was wrong to use that term altogether?
There is no such offence under the Indian Penal Code. And anti-nationalism and what is meant by her, it differs from person to person. And this kind of condition in a bail order, in an interim bail order, is unheard of. How can you say that you will not participate? That means the learned judge wants a total silence on the part of Kanhaiya. Why? Why should he completely mortgage his fundamental rights just for getting an order of interim bail? And this is an order of interim bail, this is not a judgment.
Absolutely.
And in that kind of an order, how can the learned judge say all these things?
You know, Mr. Soni,
I would say it's an act of judicial. I would say it's an act of judicial cowardice on the part of the judge.
that's very outspoken and very clear, Justice Ganguly. Mr. Soni, you were arguing against bail. You firmly believe bail shouldn't be granted. Now, when Justice Pratibha Rani terms the whole thing on this business of anti-national, and as you've just heard Justice Ganguly say, A, it's undefined in law, B, one man's interpretation of anti-national can differ from another man's. What I think is anti-national you may disagree with, and vice versa. Therefore, this is a dangerously vague and imprecise term. Its use is not just wrong, it's arguably abhorrent.
No, I am in agreement with the judgment. It's voice of the millions of Indians. Anti-national, we have said it in a lighter vein. The court has not used the word sedition. In fact, the writ petition was for quashing of the sedition charge, which has not been neither argued nor they wanted anything other than a bail.
But you just heard a former judge of the Supreme Court saying anti-national is not a crime in India.
It is a crime in India. He may
What
be,
section?
Whatever.
This is
sedition. I'm talking about the sedition.
What
sedition.
section?
We are defining anti-national slogans. Anti-national. In fact, the parliament debated. All the political parties agreed that it was an anti-national slogans being shouted at.
Can we clarify this? Are you equating anti-national and sedition as the same?
Yes, anti-national slogans which amount to sedition would fall under sedition.
The problem is that the very term anti-national is undefined. What I consider anti-national, you may not. What you consider anti-national, I may not. And therefore, you're jumping the gun in using a word that is undefined in law. It is probably undefined when used in colloquial language. How then can a judge pronounce on that basis?
The judge was dealing with section 124A, that's sedition. Under sedition, anti-national slogans amounting to contempt of the established government
but you keep describing,
and contempt of the court.
You keep using an adjective to describe the slogans anti-national when that adjective itself is undefined. No one knows. The meaning can differ from person to person. Hence, it's imprecise, vague, and abhorrent.
It may, but the court has decided that it was sedition and the case has not been quashed. Only interim bail has been granted to him to show his bona fides and improve upon his character.
Sanjay Hegde, in contrast to Justice Pratibha Rani, who not only seems to have a clear idea of what is anti-national and is also additionally convinced it's a crime, Fali Nariman, arguably India's greatest living constitutional lawyer, has written in the Indian Express on the 17th of February, and I'm quoting him, to be anti-Indian is not a criminal offense and it's definitely not sedition. Who in your opinion is right? Justice Pratibha Rani or Fali Nariman?
Any man of law would, with due respect to feminism, go for Fali Nariman. The point is this, that as we've gone around and said, that there's nothing which is being anti-national. The nation itself does not have a stake in the legal system saying that you will protect my honor at all costs. Anti-national, Mr. Soni didn't say it in so many words, but the judge has used the word very, very loosely. She has put in a condition
and
very subjectively. It reminds me of a little saying that I once heard, that you must always say what you mean. Otherwise, the danger is that you will not mean what you say.
Absolutely.
Bharat tere tukde honge, Afzal Guru Zindabad is sedition.
Just a moment, there is no clinching proof that he said it.
He conceded. He conceded to court.
The entire nation is conceding that these slogans were shouted.
Just a moment.
We are saying...
Mr. Soni, Justice Pratibha Rani in her order actually says that the videos do not record him saying it. She reports that.
This is a deflection. It is a ploy to deflect the investigation. We are not...
The judge is deflecting. Are you accusing the judge? Are you accusing the judge of deflecting?
The judge only talked about one video. We are not talking about video, we are talking about eyewitnesses.
Gentlemen, let's not get into a quarrel. Mr. Jain, I want to move on beyond the question whether Justice Pratibha Rani's conditions were wittingly or unwittingly breached, and the fact whether those conditions were legitimate or unwarranted, to some of the implications of those conditions that she's laid down, because those are equally worrying. Now, and when she rules that let me ask you the question first. When Justice Pratibha Rani rules that Kanhaiya must not actively or passively participate in any anti-national activity, is there not an inference that he did so in the past? And is such an inference valid and justified, or is it misplaced and wrong? Because to any layperson, there's a clear inference when you tell someone you must not indulge in anti-national activities, that you're suggesting he did so in the past. And there is an unfortunate inference that seems to suggest he's guilty, when in fact she wasn't even called to pronounce guilt on what he did.
No, in fact, if you see, the common thread of the judgment is that she has gone on the prima facie basis that Kanhaiya did indulge in activities which are akin to that of sedition. And in fact, the entire judgment, if you see paragraph 37 to 48, the entire discussion is aimed to describe as to how the petitioner was indeed engaged in the activities akin to sedition.
Absolutely.
Because
Forgive me,
Mr.
Jain, you're making my point. You're arguing that there's not just, you're arguing that there's not just an inference that he indulged in anti-national activities. There's in fact the assumption that he did. And that assumption is an assumption based upon some belief that he's guilty of what he's charged with, whereas in fact she wasn't even called upon to examine the merits of the case. All she was called upon to do was to grant bail. She's jumped the gun, hasn't she?
It does.
Presumption is on eyewitnesses.
Let me clarify it. No, she has not jumped the gun as you are suggesting. in any bail application, it is imperative for a judge to come to a prima facie conclusion. In fact, I have a grievance against the judgment because she has given a 6 months interim bail, which is sort of unheard of. But if you come to think of it, she has to come to a prima facie case as to whether the basic offence is made out or not. In this case, in the entire judgment, there is a common thread to the effect that yes, indeed, the petitioner did indulge in activities akin to sedition, that is inciting disaffection towards government. Actually, the expression which is used in this section is inciting disaffection towards government. Now, whether the government is equivalent to nation or not, that is a debatable issue. But so long as a person is charged, yes.
Let me bring in Prashant Bhushan, because Prashant Bhushan, this is a very critical point. You've heard Mr. Sanjay Jain, the Additional Solicitor General, say that not only is there an inference, there's an assumption that he actually was involved in anti-national and seditious activities. Now, elsewhere in her judgment, Justice Pratibha Rani says that her observation shall not be considered as an expression on merits. But once she's produced a bail order, which as Mr. Jain says, assumes he's guilty, is she not actually influencing the lower court? And is that the right thing for her to do? Because she's now prejudicing the case when it gets heard in the lower court, because she's already in her bail order assumed he's guilty.
Yes, quite apart from the fact that she has made totally unnecessary pronouncements, which in my view are political pronouncements, not even legal pronouncements. If, as Mr. Sanjay Hegde is saying, she has held Kanhaiya guilty of sedition, then I would like to ask her the same question which she asked the police the previous day, that do you know what sedition is? Because the Supreme Court has expounded on it.
Can we not interrupt? Can we not interrupt each other? Can we not interrupt each other? Carry on. Carry on.
Yeah. So you see, sedition was examined at great length by a constitution bench of the Supreme Court when precisely this question arose. If you are spreading disaffection against the government, will that by itself amount to sedition? The court held that no, if you hold that to be sedition, then it will be unconstitutional because it violates your fundamental right of free speech, and you have a fundamental right to spread disaffection against the government. And therefore the court said that unless you are inciting people to violence or public disorder, it will not amount to sedition. And yet, if the judge in this case is holding Kanhaiya prima facie guilty of sedition, then on what basis? Because firstly, there is no speech, not even any anti-national, what she considers to be anti-national slogans, that can be attributed to Kanhaiya. Secondly, just the mere fact that he was present at that meeting, or he went there as president of the JNU Students' Union, if his presence in a place where some slogans are shouted which themselves do not incite people to violence or public disorder, that can be held to amount to sedition, then I am afraid she doesn't even know the ABC of sedition or the ABC of law. She needs to go back to law school.
Let me bring in Justice Ganguly. Justice Ganguly, I want to focus on the implications of this stress that Justice Pratibha Rani lays on anti-national, which, as you said, is A, undefined in law, and B, even in colloquial use of language, two people can differ about what is anti-national. Now, because she hinges everything on anti-national, is she not, Justice Ganguly, leaving it open to the police to determine whether Kanhaiya's future actions are anti-national or not? And if she is leaving it open to the police to determine, is she not therefore also giving them a wide range of grounds on which they could possibly rearrest him if they want? All of that she's laid open.
Yeah, I agree with you to a large extent, also agree with Mr. Prashant Bhushan about the learned judge's discussion on law. I would say that the entire judgment proceeds on a subjective basis. There is hardly any objective consideration. And I am asking you a question. I am sure you have read the Tagore's piece on nationalism. There Tagore said that at times nationalism is a menace. Then Pratibharani will hold that Tagore is anti-national.
She would have to if she's logical and consistent.
The poetry, yes, if you read the poetry by Qazi Nazrul Islam on rebellion, then the learned judge will hold that poet as anti-national. I mean, this is a dangerous precedent. And I tell you, what is the requirement of a bail order? I have had passed some bail orders in my life, in my humble career as a judge. Now, in a bail, the word, what is meant by bail is not defined anywhere. According to me, bereft of all verbiage, bail order means an order which will ensure the presence of the accused at the time of trial. Unless he is guilty, he cannot be kept in jail perpetually. So when he asks for bail, only these three things are to be considered. What is the nature of the charge and what are the materials against him? No prima facie guilt is to be found.
Absolutely.
Okay, this is wrong. This is wrong idea.
And therefore,
prima facie guilt. Only thing, what are the materials against him? What is the charge? And secondly, whether if he is released on bail, he will tamper with evidence,
and
or he will run away. These are the basic considerations.
Therefore, Justice Ganguly, you are underlining the point I made, that any inference of guilt, leave aside any assumption, as Mr. Jain put it, is completely wrong. It should not be. Should not be.
He has the protection of innocence.
Absolutely, which unfortunately the learned judge has overlooked or ignored.
How can you say prima facie?
Let's come, Mr. Soni, to another aspect of Justice Pratibha Rani's bail order. She says, and once again I'm quoting her, as president of JNU Students' Union, he will make all efforts within his power to control anti-national activities in the campus. Now, JNU is a hugely spread out campus, and I'm told some of the hostels are as much as 2 kilometers apart from each other. How can he be held responsible for what happens in a hostel where he isn't present, which may be 2 kilometers away from where he is, and about which he knows nothing? How can you hold him responsible? Yet that's a condition she's laid down.
I heard the speech of JNU president yesterday. He says the entire JNU has been put to shame because of his solitary arrest. So if that has happened because of his arrest, within that 50 minutes of his speech, he did not even condemn those so-called anti-national slogans which said Bharat ke tere tukde honge.
Just a moment. At a press conference that he held this afternoon, he made it clear. At a press conference this afternoon, he's made it clear that he does not support anything that's anti-national. He does
not directly condemn those incidents that happened on the 9th.
But he may choose it. He has a right as an individual
to say that we are sorry something happened in JNU on the 9th and we want to get over with it. So JNU comes out of it. If JNU gets defamed because of his being arrested,
the question I asked you,
he owes a duty to JNU.
The question I asked you was a different question. First of all, is it right for such conditions to be laid down when granting bail? And secondly, there's that additional condition that he is to be held responsible for everything that happens in the campus, and if the hostels are 2 kilometers apart, how can he be held responsible?
He will not be held responsible.
She says so.
But his criminal conduct, if found to be anti-national once over again, it will be a corroborative evidence when we collect it after 6 months when he comes for bail.
In other words,
we'll be collecting that evidence.
Forgive my colloquialism, but in other words, you're like a hound dog. You're going to be watching him for everything he does.
Yes, we have been directed to watch him, and he should be aware that he will not conduct any anti-national activity anymore in
Once
JNU.
Again, that word anti-national is undefined.
It's an elite university. We respect it as that.
Sanjay
Leave it at that.
Is there also another danger in Justice Pratibha Rani's comments about anti-national slogans, their impact on the families of martyrs, and as you mentioned, her view that this is a kind of infection which needs to be controlled, it could require surgical intervention, even amputation. Is there a danger that all of that could influence the lower court hearing the case against Umar Khalid and Anirban Bhattacharya? After all, is it not possible that a metropolitan magistrate hearing that case might feel he has to defer to a senior high court judge's views?
Well, the metropolitan magistrate will have no choice but to obey. That's the way the system goes. That the magistrate has to listen to the high court and the high court has to listen to the Supreme Court. The rule of law works that way. And if it doesn't, if anybody steps out of line, the superior court can overrule them. That is precisely why judges, good judges take great care with words in judgments. They use as little of them as possible.
She is really a good judge.
Well, let her judgment speak for itself, and many of us have great differences with that judgment.
Just a moment. On this issue, Justice Ganguly, I'm going to ask you for a short, sharp answer. You've heard Sanjay Hegde suggest that Justice Pratibha Rani is not a good judge. This is a loose, badly worded judgment, raising concepts like anti-national, which are undefined and over which there is no agreed understanding. You've heard Mr. Soni interrupt and say she's a good judge. Can I ask you, in your opinion, judging by just this bail order, good or bad?
I can't say the order is awfully bad, but I can't say she is a bad judge. I would expect this is a slip. Must have been a slip on her. I'm sure she unnecessarily came under pressure by writing all this poetry, this, that, or the other. She made a heavy weather about a small thing.
As you said, you can't judge the person, but this is an awful
Let the judgment speak for itself.
Order.
It's a balanced judgment.
That is an important thing.
I'll tell you.
Can I stop?
I'll tell you one thing.
Yes, very quickly, sir.
Can I say one thing? Yes.
Good.
The way she has said, put her words, that it needs amputation, this, that, and the other. Does it not incite the police into violent activities? Can you think of this?
Absolutely.
Why would police come into it? I don't understand. We are investigating a matter.
You are interrupting someone, Mr. Soni. Restrain yourself. And he's a former judge of the Supreme Court.
Who is going to do the amputation? He said there's a gangrene. This develops into a gangrene. If necessary, it has to be amputated. What is meant by that?
Prashant Bhushan, given that you believe Justice Pratibha Rani's comments were improper and unjustified, and secondly, given that they could have terrible implications on not just Kanhaiya Kumar's future but that of his colleagues, should his lawyers immediately petition the Supreme Court to get those observations erased and scrapped?
Actually, the problem would be that once he has been granted bail.
Carry on, Prashant.
Once he has been granted bail, if you go up in appeal against this order, if Kanhaiya goes up in appeal against this order, the Supreme Court could well say, look, I mean, why you bothered about these observations, etc. You've been given bail, you relax, etc. But I agree with you that these observations are seriously problematic.
Okay.
They would have a chilling effect on the magistrate who would be deciding the bail of Umar Khalid and Anirban Bhattacharya, etc. There is a serious problem with these observations, and some way needs to be found. Perhaps when Umar Khalid and Anirban's case comes up further up to the High Court and to the Supreme Court, perhaps at that stage these observations could be dealt with.
Let me put that point to Justice Ganguly. Justice Ganguly, you are a very respected senior former judge of the Supreme Court. You were open and honest in saying that this is an awful order, your precise word. You were also open in saying that this could be an incitement to the police. After all, as you said, who will do the amputation? Given that this is an awful order, what should be done about it?
Now, I first say that Kanhaiya is worse off after the bail order. But previously he was in jail. Now he is out of jail, but he is virtually in prison. Look at the implications of the order. He is responsible for everything happening, anything happening, which according to the learned judge is anti-national anywhere in the campus of JNU. Suppose tomorrow there is a complaint to the judge. There's something anti-national is happening there, and therefore the bail condition is breached. The judge under his order will immediately recall the interim bail. One cannot live under a stress of perpetual anxiety like this.
So what should be done about these observations?
I think his lawyer should decide. I'm not in an advisory capacity, but his lawyer should at least first apply before the same learned judge for relaxation of this condition. that these conditions are not called for.
And if that
the learned
fails?
judge refuses, then they can go higher up.
Can I ask you this? You have been a judge of the Supreme Court. If they were to go higher up to the Supreme Court, do you believe the Supreme Court would erase these observations?
Well, it's very difficult to say that, but this is Supreme Court would at least see that these are observations which is wholly uncalled for.
Let me bring
First,
in
you should
Mr.
approach the learned judge that these are the observations.
Let me bring in Mr. Sanjay
Observations which
Jain.
is uncalled for, kindly remove them.
Mrs. Jain, you've just heard Justice Ganguly, a former highly
Yes.
respected Supreme Court judge,
Yes.
say that this bail order leaves Kanhaiya Kumar worse off than he was when he was in jail. Because now, on the smallest pretext, someone can go to the judge and get the bail removed for things that he's not even responsible or accountable for. Do you wish at all to defend?
See, there are two ways of looking at it.
Which is your way?
There are two ways of looking at it. You see, one way of looking at it is that let's not read too much into the bail order. After all, it is just a bail order, and at the end of the bail order, it is clarified that these observations are only prima facie in nature.
In other words,
And I
ignore
would
Justice
beg to
Pratibha
differ
Rani.
with Justice Ganguly.
Forgive me, what you're suggesting is ignore Justice Pratibha Rani.
I am not saying.
She
I am
doesn't
not
know
saying
what
that.
she was talking
No,
about.
I am not saying that. I am not saying that. I am not saying that. Please appreciate what I am saying. I am saying that any bail order has to be read and understood in its context. While I would agree with Justice Ganguly to that extent that if this bail order is sought to be implemented in its letter without spirit, if only letter is followed, then Kanhaiya may be in trouble, because some of the conditions which are imposed in the bail order may not be possible to be monitored by any agency. But if we are not reading too much into a bail order, if we just take it as a bail order, essentially what the bail order forewarns him, that please do not indulge into any activity of the nature in which you had indulged on the fateful day.
Well,
the day
yes,
for us
even
is
that,
relevant
even that is an
9th
assumption of guilt that many
9th of
would
February.
question. But
Yes.
let me put to Mr.
No, it is not
Hegde
a-
the
no, no.
first point. The first point is a very interesting point, that actually this bail order could land Kanhaiya in terrible trouble because it cannot be monitored. Now, worse still, if it can't be monitored, it's actually providing grounds to the police to implicate him under false charges. And as you heard Mr. Jain say, if the bail order is followed in letter rather than spirit, right, then it's trouble for Kanhaiya. Who's to guarantee the police will not follow it in letter and ignore the spirit? Why are we relying on the police to such an extent? What gives us confidence we can trust them to make that critical distinction?
Well, I don't have too much confidence in the police. Leave that aside. This order also puts the High Court in more trouble, because it makes the High Court vulnerable to every Swami or every petitioner in person who says, Kanhaiya did X, Y or Z, please come and please now cancel the bail. That is what is going to happen.
She's tied herself in knots as well.
She's put herself in a prison of her own patriotic imagination.
In other words, it's not just Kanhaiya who's been put into a prison, as Justice Ganguly said, by the bail order. She's put herself in a prison.
Absolutely.
Because now, what will she say if any Swami, as you put it, right? And I take it you don't mean the man, but you mean the designation.
I'm speaking South Indian.
Absolutely. Any Swami can come and cause a problem for her because she'll have to respond. You were defending the only person today who's fully and totally defending the bail order. Even Mr. Jain, your senior in this case, has actually accepted that if followed in letter, this is a bad bail order. After hearing Mr. Jain being critical, Justice Ganguly being critical, and I won't mention the others, do you want to change your opinion of Justice Pratibha Rani's order?
Certainly not, because I am too sure that the Delhi police and the special prosecutors and the additional solicitor generals who are engaged in this case are mature enough and will not go into this kind of a thing.
Other than the fact that you happen to be their counsel and you therefore can't speak against them? What gives you the confidence the police are mature enough?
Even the police is mature enough. They will not do such kind of a thing. They will see it and letter and
You know,
spirit.
a moment ago, you were defining anti-national on the basis of what the people of India consider anti-national. The people of India have no faith in the police. So if you go by that same criteria, your own logic would say you can't trust the police.
They may not, because we are still we are investigating the matter. We may have some other evidence that comes before us, and after 6 months we'll
May
see.
is a big if. May have some evidence is a big if. You can't do justice on the grounds of a hypothetical if for the future.
We are still investigating the matter. We still have enough time.
I want to come back to you, Justice Ganguly, and ask you a question from your very lengthy decades of experience as a judge. Why do judges pass orders with such unwarranted sweeping observations? Unfortunately, this is not the first time it's happened. Arguably, even the National Herald case in the same High Court in Delhi led to similar observations that have been contested. Some of those were subsequently even struck down by the Supreme Court. Why do judges feel a need to express themselves in these vague, sweeping, indefensible generalizations?
I have seen some judgments, but the judgment of Madam Pratibha Rani is unique in its character. You see, have you seen that in the judgment she has noticed that Standing Counsel Criminal for Government of India did not oppose bail? Did not oppose bail for Kanhaiya. But the judge has passed this kind of an order.
So in other words, you're saying that she is a uniquely bad order. You're saying this is a uniquely bad order, and you're suggesting she is a uniquely bad judge.
Uniquely bad judgment.
Okay.
I'm not suggesting she's a bad judge. I am not saying that. She's a bad judge. I wish her well. I have all sympathy for her. I wish her well. But I don't say she's a bad judge. But the order is. I hope she will not pass similar order in future. That is only I hope and pray.
I don't
say she's a bad judge.
Justice Ganguly, I don't want to attribute motives at all. That would be wrong. It would probably be contempt of court. But there are some who suggest that judges, not just Pratibha Rani, but all judges, given to the temptation to make these sweeping generalizations that are indefensible because actually they are quoting newspaper or television headlines. Do you sometimes suspect that of your brethren?
Well, it differs, but the question is judges also do their duty under great pressure. You see, it's a question of some judges might have gone a little beyond the normal line. But you must understand the judges are under great pressure.
Okay.
It is for the judges to absorb the pressure and then do their duty.
Okay.
That is what is called from the expected from the judges.
Let me ask you, Justice Ganguly. I want to interrupt and ask you one more question because we are running out of time. And that's to do with whether bail should have been granted only for an interim period of 6 months or whether Kanhaiya should have got full bail. Justice Pratibha Rani in her order accepts there is no video evidence of him shouting slogans. She also accepts that the videos are doctored, and now we know today that even the eyewitnesses who had claimed he had made these statements, according to several papers, those eyewitnesses have recanted. Given those three facts, should Justice Pratibha Rani have given full bail rather than conditional bail for just 6 months?
In my opinion, of course that's my opinion, the Kanhaiya's case is a case for grant of straight bail. You would have been granted bail without much ado.
That's very clear.
This kind of order is wholly uncalled for. Wholly uncalled for.
There could be no stronger indictment from a former judge of the Supreme Court.
This does not do any good to the judiciary, no good to the judge, and no good to the accused either.
In other words, this order is a black mark against the Indian judiciary.
I don't say that. Let us forget the order as soon as possible.
But it does no...
Mr. Jain said we should not follow the letter. We should not follow the order in letter and spirit. Well, spirit is a volatile substance. I don't know what is meant by spirit. That means nobody can follow this order. This is an impossible order which she has passed.
Honestly, there can be no clearer indictment.
Absurd, impossible and absurd.
If I was the judge of whose order this would be said, I would feel deeply embarrassed because it was one of my seniors, a former judge of the Supreme Court, saying that mine is an impossible order, an awful order, and an order that does no good to the judge, the High Court, or the judiciary. I can't think of a stronger condemnation than those words from Justice Ganguly.
But I wish the judge well, I wish her well in her career. Let her improve. Let her improve.
Yes, indeed, sir. We all wish Justice Pratibha Rani well, and we all endorse that sentiment. Let her improve. My thanks to all my guests for joining me. If you have been, thanks for watching. Goodbye. Good night.
Terrorists struck at the Indian consulate in Jalalabad. We are getting you the first images of that horrific terror strike that were caught on camera. A CCTV camera outside the